versus Knutson 2123 here for a final pretrial. So we do, as you indicated, Mr. Stoltz, have a trial date on the 23rd. Let me just ask this. Are you prepared to go forward on that day?
Are you speaking to me as the petitioner?
Yes.
I haven't made pretrial disclosures. I apologize. It's a little confusing as to what what the issues are, but I think if we could continue if you have an opening a couple of weeks out, that would be helpful, and we could comply with Rule 26. Or I think it's A4 pretrial disclosures.
Well,
get some materials together. It also might be helpful. Just a suggestion. I don't know if the court does this. Probably do a judicial settlement conference, or we don't have a custody evaluation, but so we wouldn't have a 4903, mediated settlement conference. But Ms. Williamson, I'm sure she's done a tremendous amount of work in this case, and it might be beneficial to the parties to hear what her recommendations may be ahead of trial, so it's not there's no surprises. Perhaps a judicial settlement conference along the lines of what 4903 settlement conference might look like, but for the purpose of hearing from primarily for the purpose of hearing from Ms. Williamson. Any thoughts on that?
Well, I'm always interested in judicial settlement conferences. I realize there has not been one in this case. I think there's a layer of complication. Let me hear from Ms. Williamson on that, because I think that was her work, and then I'll hear from Mr. Knutson.
Your Honor, I don't have an objection. I don't know if Mr. Knutson would about continuing this. I had fully intended on letting the parties know a week in advance of trial what my recommendations would be. So I don't think there's an issue with the parties being surprised by what my recommendations would be. And I guess unless Your Honor has any further questions on that, I would submit.
All right, Mr. Knutson, and I'm sorry, is it Knutson or Knutson?
It's either. Both work.
Okay. Let me hear from you. So the issue is this. I normally do require a judicial settlement conference, unless the parties tell me there is absolutely no way that's going to work, or unless they've already had a failed mediation and they're not interested. I normally do require it. I have not. Yeah. So let me get to that. So a judicial settlement conference is a settlement conference. It's in front of another judge, a judge who's not assigned to the case. So not me, it would be another judge in West Jordan. There's no charge to it as there is with a private mediator. What happens is we would get dates from other judges in West Jordan. The proceedings in that conference would be confidential, meaning that I wouldn't know anything about what was said. So if the case were to go to trial, my determinations wouldn't be affected in any way by anything that happened in that settlement conference, because I wouldn't know what happened. At that conference, you would have the opportunity. It's not formal, it's very informal. You would have the opportunity to essentially explain your position to that judge. The petitioner would have the opportunity to do the same. You would certainly review Ms. Williamson's conclusions in advance of that, and she could be present at that, although she wouldn't have really a significant role. So it can be done by WebEx, or it can be done in person. There's really no downside to doing it. When I do judicial settlement conferences, because I do them for cases that are assigned to other judges, what I usually tell the parties, and I hope it's helpful, is that if you can resolve a case at a settlement conference in front of a judge or otherwise, you still have control over the issues. Once you actually go to trial on a case, you've given that control to the judge who's making those decisions. And that person will certainly do their best, but you have to realize that at that point, you know, you are no longer in the role of making decisions, which you are if you're still in settlement posture. So if that is something, it sounds to me like the petitioner is willing to engage in that. If that is something that you would be willing to engage in, then what I would do is get potential dates from other judges when that could occur. It would usually be a half day sort of thing.
No thanks. That sounds awful. No.
So, Mr. Stoltz, I know it's a little bit different when we don't have counsel on both sides, but if I have a party who is just not interested in that, and frankly, I think we may have broached this subject at a prior hearing, and I think that Mr. Knutson had the same response. If I have a party that's just not interested in having a discussion, then I don't frankly want to waste anyone's time or money, at least on your end. So here's what I'm going to suggest. I'm also a little bit confused as to what the issues are. I would want some time to review Ms. Williamson's submission. I think that you both need to make submissions. I would like some specificity as to what the issues are for trial. I do have some availability. I'm going to push this out a little bit to give Ms. Williamson time to get that in. I mean, I understand you're on track, Ms. Williamson, but I want to give everyone sufficient time to review that document and give you all another date for trial. And I'm going to give you some deadlines as well. Mr. Silver.
Sorry,
Yeah,
Your Honor, just
go
to
ahead.
clarify, you're requesting that I actually file a report with the court or just to the two parties?
Just to the two parties. I assume that is going to be something that would be submitted at trial, but Mr. Stoltz, correct me if I'm wrong.
Sometimes they're done in a written format, and other times they're just presented as recommendations, kind of in a format. But I think in this case, it would be helpful to have it in writing for the parties to carefully evaluate it. I didn't hear Mr. Knutson's response, but I can only infer that he said no. Absolutely. Observation. I did have last week. I had what turned into a 2-day judicial settlement conference with Judge Shaughnessy in a case that was set for a 3-day trial. And remarkably, I think there's something about being in front of a judge in a situation like that where you're, the mediator is a person who has presided over dozens, maybe hundreds of trials similar to these fact patterns. They can say, to a party, candor without saying it to one side or the other, or perhaps in front of both parties. Like if this case were in front of me today and I were deciding these facts or making findings of fact on these particular issues based on what I'm seeing here, this is the way I would be inclined to rule. And that is a thing that is unique. It's unlike any other kind of mediation. So I don't know that I appreciate the explanation you offered to Mr. Knutson, but I'm not sure that he fully understood what was on offer.
Well, you're right. First of all, Mr. Stoltz, in terms of your characterization of a judicial settlement conference, I'm hesitant only because when I heard Mr. Knutson's response, I remembered that this is frankly the second time that we have discussed this, and I think he had the same response the first time. So I do have some hesitation there. Having said that, here's what I'm going to do. I am going to get you a new trial date. I'm looking at my calendar right now. Mr. Knutson, did you hear everything that Mr. Stoltz just explained with respect to how judicial settlement conferences work?
Yes.
All right. And he's right in that you do have the benefit, if you do a judicial settlement conference, of hearing another judge, not one who will decide your case, but who frequently decides cases, domestic cases, hear their input as to what they think may happen. It's not, they don't have a crystal ball. They can't tell you exactly what I would rule. That's sort of a matter of judicial independence, but they can give you the benefit of a lot of experience in deciding these sorts of cases.
Okay, no thanks. I don't want to participate in that at all. Sounds like a big waste of time. It's no offense to anybody.
So, Mr. Stoltz, I frankly, I hear where you're coming from, but I am not really interested. I mean, if both parties aren't coming to that with an open mind and willing to engage, then I think we're wasting everyone's time. Obviously, if there's any change of heart on that, then reach out because I'm happy to get some dates.
No thanks. We've been doing this for 6 years, trying to just get to the point.
All right, here's what I'm going to do. Mr. Stoltz, remind me, did we think that we needed a full day for this?
We do. We could probably do it in 2 half days if the court doesn't have much time allocated in one slot.
Sorry, Mr. Stoltz, I can't hear you.
Your Honor, we did have a full day set. I think we could do it in 2 half days if the court doesn't have 1 full day slot.
Let's do that. I think that is a good suggestion. So here's what I'm going to propose. We could do the first half day on, let's see, we could do September 28th in the morning. Would that
That
work?
works for me, Your Honor.
Mr. Stoltz, does that work for you?
The 28th at 8:30, or what can we do in the court?
Ms. Williamson, sorry, you're going to have to translate.
Sure. She just said the morning of the 28th for the
Yeah,
first
that's
half. I don't know if Your Honor heard him, but he said that's fine.
Okay, yeah, 8:30. Mr. Knutson, does that work for you?
Yeah, is that in person or is it on the?
It's in person.
Okay, cool. Yeah, it
And
works.
then, okay, perfect. And then let's go ahead and do a follow-up right now in case we cannot get that done. I do have first appearance that day, so will need to conclude at noon because I need to be at Matheson by 1. We can do, let's see. We can schedule the morning of October 5th.
That works for me, Your Honor.
That would actually start at 9. Will that work for everyone else?
Yeah.
Noon thing that I have to appear at via WebEx, but 1:30. So no anticipated problem there.
Yeah, and I have a criminal calendar that afternoon, so that really shouldn't be an issue. All right, let's talk a little bit about disclosures. So here's what I would first like. I want both parties, I know this is this is not necessarily by the rule, but I think it would be helpful here. I want both parties to submit a very specific list of what they think are the issues that are remaining for trial. If you can do that by September 23rd. And then, Mr. Stoltz, when do you think you can have your pretrial disclosures done?
We have it by next Friday, the 16th.
September 16th? Yeah, that's fine. Mr. Knutson, I will need, let's see, September. I will need pretrial disclosures from you as well. I don't believe you had submitted. I think I had already ordered them when we thought we were going to trial on the 23rd. So let me go ahead and have yours by the 23rd of September. So Mr. Knutson, what that means for you is that on September 23rd, I need you to submit a list of the issues that you think are remaining to be decided at trial. very specifically, as well as your pretrial disclosures, documents you intend to use, witnesses you intend to call, et cetera.
Okay.
All right.
What is this an official form? This is a document? This is a PDF?
No, what you can do is you can just email it. It will need to be on a written form. It doesn't need to be official, given that you're not
Okay.
represented by a lawyer, but if you can just email that to my team.
Okay.
Okay, it's important because if you don't disclose who your witnesses are and any documents you have, then you can't use them at trial.
Okay.
All right. Anything further?
Yeah. I submitted a motion 2 months ago to dismiss opposing counsel and to find other party in contempt.
You did, and I know that there wasn't an opposition filed on that. I did review the motion, and I'm denying the motion. There isn't a basis to exclude opposing counsel. I understand that you have some concerns about whether orders of the commissioner were being followed. However, your remedy in the face of those concerns is not exclusion of opposing counsel. There's not a legal basis for that. With respect to the issue of contempt, I am pretty sure that Commissioner Tack did certify that issue on your side, on respondent's side. So that is something that can just be certified and addressed at trial.
Is there a remedy for it? Like, can we fix the problem?
Well, I can't give you legal advice, sir. If you have questions with respect to that, what I would suggest that you do is reach out to the court's self-help center. Their emails on the website, but I can't give you legal advice. Let me just finish. There is no basis for excusing opposing counsel. If you have concerns about the behavior of opposing counsel, there are certain things that you can do, but I can't give you advice in that regard.
The thing I'm concerned with is, are the people approved by Amy Williamson approved or not? Because I have a whole list of people that are supposed to be able to help me see my kid, and the other party just says no, they're not approved. So
Okay,
how do I prove that they're approved?
And that's not an issue that is before me right now. That is a different issue than excluding opposing counsel. So what I would ask, because I have, as I said, I've got a jail calendar I need to start here. What I would ask is that you perhaps, Ms. Williamson, are you really willing to have a discussion with Mr. Knudsen about that?
Yeah, I'll have a discussion with Mr. Knudsen and also Mr. Stoltz about that.
Okay, so what I would ask, I'm not going to address that this morning. I simply just don't have the information in front of me to do that. So let me ask that the three of you discuss that in some fashion. If there's still an issue remaining that needs to be determined, then, you know, we've got a trial date in a few weeks, so I will address that at trial. All right, thank you, everyone. Appreciate it, and we will see you for trial. If there's any change of heart with respect to a judicial settlement conference, then please let me know.
Thank you, Your Honor.
Thank you.
If there is there a specific